Good morning, good afternoon, good evening, depending on where you are. Yesterday we had the Lori Vallow Daybell hearing on her request for a new trial. If it had been granted, it would likely have been joined with Chad's, and the defense was arguing for that. Risky strategy, though, because if she got a new trial, the death penalty could be back on the table. So um, you've already lost once. Do you really want to go there? Um, but we know that Judge Boyce denies it, and we're going to look at the hearing and discuss various points along the way. Why the defense's arguments are kind of dangerous, and where it kind of fell apart for them in the prosecution's answer to their arguments, and then the judge's analysis. So without further ado, I guess we'll get going. So here we go.
All right, good morning, everyone. We're going on the record on case CR 22211624, State of Idaho versus Lori Noreen Vallow. The defendant is here present, appearing with counsel, Mr. Archibald and Mr. Thomas. The state's here represented by Rob Wood and Lindsay Blake. Court would note there's a courtroom conduct order in effect that prohibits the video or audio recording of any of these proceedings for this hearing today. I'd ask all in attendance to please comply with that order. Before the court this morning is a motion that was filed by the defendant, a motion for new trial filed on May 25th. The state filed a response to the motion on June 7th. The court's reviewed the pleadings and am prepared to hear argument on the motion. Who is going to be making argument on behalf of the defendant today?
I will, Your Honor.
All right, Mr. Archibald, if you're prepared, you can make your argument at this time, and then I'll hear the response from the state.
May I remain seated?
Yes, you may, Mr. Archibald.
A motion for new trial was filed due to what we believe were errors during the trial. The Idaho statute that governs this motion is very specific on what we can bring up. Our client still preserves all of her other appellate rights other than what's contained in this motion for new trial. So because of the conviction, there will be a sentencing unless this court grants a new trial. If there is a new trial granted, we understand there's a trial set for Chad Daybell set for next year. And I would anticipate if the court grants this motion that the state would then seek to combine the cases once more. So with that in mind, the reasons that we're asking for a new trial is set forth in the motion, and I'll just be brief as I argue the three issues that we brought up in our motion.
Okay. Yeah. He's trying to portray it as there isn't going to be any real additional costs if Lori gets a new trial date. But the thing is, the trial will run longer. I think it's set for 3 weeks. But I think Lori's ran longer than that. And if you're having two, and both sides are going to be cross-examining and so forth, I would be shocked if the trial was under 6 weeks, quite frankly. And Yeah, it sounds good. Of course, it's going to be a lot cheaper than a whole separate trial, but it's not quite as simple as they're portraying. So, okay, let's go back.
The court misdirected the jury in a matter of law as it related to the jury instructions on conspiracy. And I don't fault the court as much as I do the government for the way that this information, this indictment was filed. It was pretty clear from the indictment that the government started out with presenting this to the grand jury that the conspiracy involved at least 5 people: Chad Daybell, Lori Vallow, Alex Cox, and other co-conspirators, both known and unknown. The grand jury did not invent that language. That is language drafted, composed by the government. So when the government presented this case to the grand jury signed off on it. And so when my client was arraigned, she was given a copy of the indictment. She can read, she can understand that the conspiracy that is alleged against her was consisting of 5 people. The court then read this language to prospective jurors during the jury voir dire process, during that 2-week process. And then the court read this language again to the jury at the start of the trial, start of our, so during the 7 weeks that we were in Boise, the 2 weeks of jury selection and the 5 weeks of trial, the jury knew this language. They knew that because the court had read it to them. The court had read this language to them as it was drafted by the government. And so for the court and the government to then, at the end of our 7 weeks in Boise, to just all of a sudden say, just kidding, it's not really 5 people, it's 2 or more, because of the definition of conspiracy. And so this was a mistake created by the government, that the court was obligated to read the indictment to the jury. And then the jury instructions defined conspiracy differently than how the government defined it. And so the state is relying on the Yang case, saying, well, you attorneys know what a conspiracy is, so no harm, no foul. So you attorneys know the definition of conspiracy, so it's no big deal. And I think the Yang case is bad law. The Idaho Court of Appeals, I think, messed up on that. And I think that's one issue that the Idaho Supreme Court will visit on this case, is where the government defines it. The grand jury endorses a conspiracy of 5, at least 5 people. Is it then okay to say, well, you attorneys know what a conspiracy is, so no big deal? I think it is a big deal, and I think that issue is cause for a new trial. Secondly, I think the court misdirected the jury in a matter of law as it related to the amended indictment. Again, after our 7 weeks in Boise, the state and the government moved to amend their indictment, and for a quote unquote clerical error. And as we noted at the time with our objections, this was not a clerical error. There were 5 prosecutors working on this case from day one. All 5 prosecutors submitted this indictment to the grand jury. The grand jury signed off on it. And then at the end of the state's case, they moved to amend their indictment. The defense objected, And so we believe that that this mistake from the way that the government drafted their indictment, it was prejudicial and should not have been allowed. I'll remind the court that the defense tried to get this indictment sent back to the grand jury for errors and clarification. The government objected and repeatedly and said everything's fine. Everything that the grand jury did was just fine. Everything the grand jury did was perfect. And so we attempted to have this indictment sent back to the grand jury, and it was rebuffed at least twice. And so then the government gets the opportunity to amend the indictment after our 7-week trial, and the court grants it. And we believe that was error and constitutes a reason for a new trial. Our third point for asking for a new trial is based upon a news interview that a juror gave to a reporter. I quoted the part of the conversation in my motion, and it's not necessary that I present a copy of that to the court, a verbatim copy, because the state agreed with what was said. So the state in their responsive brief did not say, no, sir, that's not what he said. They agreed that that's what he said, and then added an additional interview in their responsive pleading. And so that's based upon the reporter and the juror's statements. And I will note that both the juror and the reporter, were very respectful of the process, very respectful to the court, to the attorneys, to all of the court staff. This juror indicated, and the reporter indicated the respect towards the process from the start to the finish. So I'm not criticizing either of them for anything derogatory that they said. What I am indicating is that our 404B objections they're tough. They're even tough for third-year law students to grasp. This evidentiary issue of allowing in bad acts, not to prove someone's a bad person, but for some other reason. That is really difficult. It's difficult for law students. It's difficult for lawyers. It's difficult for courts. And so this is a pullable issue on the 404B. And this conversation between the juror and the reporter just demonstrates some of that confusion, because on one hand, the juror says it was very clear. We followed the instructions. It was very clear. But then makes an erroneous statement. The Arizona evidence and testimony is only for demonstrative purposes. And we know that that's not true, that the Arizona evidence and testimony was not for demonstrative purposes. That was the 404B evidence to show.
One quick comment here. In the appellate process, the court always has to defer to the jury on these matters. So, if the jury says, that found one way, you can't go saying, they this just isn't a valid. You have to go with the no, this just isn't going to fly. So, okay, here we go again.
Some other reason other than the defendant is a bad person. And so what was demonstrative was the government's summaries from the FBI and other law enforcement. So those two issues got confused. So the juror on one hand says it was clear, we followed, but yet we know that it was confusing because he defined it wrongly. And so based upon our motion for new trial, if the court grants the motion, then we'll again attack 404B evidence. Some courts just stay a mile away from this character evidence because of the traps that it sets. And I think this is a good indication as to why a court would want to stay away from 404B evidence, because it does tend to confuse the jury. And so with those issues, Your Honor, if the court denies this motion for new trial, of course, we'll proceed to sentencing, and these issues can be taken up on appeal. If the court.
Okay, let's take a break here from, oops. Darn, my doorbell just went off. Okay, maybe we'll do it when he finishes here in a sec. Okay, I'm going to let this run and answer the door here.
Grants this motion for new trial, we would expect that our cases would be combined with Chad Daybell's trial next year. And so on behalf of my client, we never asked for a separation of the trials. It was Chad Daybell who asked for his own trial. And so that's why we're okay. If the court grants this motion, we're okay with having our case reset at the same time as Mr. Daybell's trial. That's all I have.
All right, thank you for the argument on your motion, Mr. Archibald. Who's going to be making the argument on behalf of the state?
I will be, Your Honor.
Okay, Ms. Blake, if you'd like to present the state's argument, you may.
Thank you, Your Honor. First off, the state does recognize that under Idaho Criminal Rule 34A, the court may grant a new trial on any ground permitted by statute. In Idaho Criminal Rule 34, the statute they are specifically referring to is Idaho Code 19-2406. Within that statute, there are 7 grounds for which, based on which a defendant may ask for a new trial. The defense in this matter has focused on 3 of those 7 grounds.
Oh, okay. That was really, really quick. Neighbor boy just wanted to ask if they could use my garbage cans for some overflow. Yeah, I wanted to go at this point since the argument from our defense was just presented regarding the testimony of juror number 8. So let's go hear that portion of the Nate Eaton interview here. So let's see. And Aowen is saying hi. Okay, here we go.
She made it known that she was not happy. She didn't agree. And there was one very powerful one for me. When Audrey, I forget her last name.
Baratario.
When Audrey got up there and gave her testimony, and Lori's demeanor was very aggressive. She wanted to, it felt like she was going to jump out of that chair and that desk at any moment. She was leaning forward in a very aggressive manner, you know, her body language. That led me to believe that, again, she's an alpha, and if she could control the situation on somebody who was perhaps gullible, maybe a weaker mindset, that she would.
Did you ever get to a point hearing some of the religious stuff and text messages where you thought, this is complete nonsense? Or as the defense called it, crap, weirdo, stupid? I mean, and were you able to process all of that?
I don't know that you can ever process that. I think you try. I think you try to reason, make the best of what you have. but definitely don't understand how can a grown person, two and more than two, believe all of that. And yeah, it makes me question a lot of things.
Having seen all the evidence, all the thousands of hours spent, how would you describe the efforts of law enforcement?
You know, I think they did a good job with what they had. I don't know. I don't know that you ever can really train for something like this. I think they did a good job with what they had. You know, you question some things that happened, and I'm sure there's a reason for it. I'll probably never know, but you question, had some things been done different early on, would any of us be here?
Do you have an example of one of those things?
Well, and we didn't consider this during our deliberations because it was clear to us, the instructions were clear. Arizona, evidence and testimony is only for demonstrative purposes.
Sure. Yeah.
And we all were very, very respectful of the rules, the directions that we were given. But now being removed from that, I think the police department in Phoenix had some significant red flags that, had they been followed up on, you know, maybe we're not here.
Do you mean after Charles was shot?
Before and after.
Before and after. Before, yeah, you're right. Before he was shot, that body cam. How would you describe the prosecution, their overall case? And sitting in a juror's seat, you trying to comprehend it all and understand it all. How would you describe it?
I felt like there were a couple of them that did a great job. They were very much matter of fact, to the point, easy to follow. And then you had a couple that were hard to follow sometimes, were hard to stay engaged.
Okay. I think that's all of the relevant section, which the defense was referencing, you know, saying, oh, they shouldn't have concerned themselves at all with the Charles Vallow thing. And he's trying to say, we know their mind better than they do. And that they can't do it for demonstrative purposes. And in how the appellate process works out, you have to defer to the jury on those things. And so anyway, let's go listen to the rest of the rebuttal from the prosecution, being that this is the request for from the defense. The defense goes first, and then the state, because of course the state has to answer what issues the defense brings up. So it's kind of the reverse of how it is in the trial. So here we go.
Reason. In this particular case, the defense has focused on subsections 2, 5, and 6. 2 being that the jury considered evidence not introduced at trial. 5 being the court misdirected the jury in a matter of law or erred in deciding a question of law during the trial. And 6 being the verdict is contrary to law or evidence. The first one, the defense argued, and we focused on, deals with the modification to the jury instructions from what was in the indictment to include the term and/or rather than the and that was originally there, dealing with the charges of conspiracy. A criminal conspiracy is defined by Idaho Code 18-1701 as two or more persons combining or conspiring to commit any crime or offense prescribed by the laws of the state of Idaho, and one or more of such person doing an act to affect the object of the combination or conspiracy. Pursuant to the plain language of the statute, the defendant was on notice that she was accused of conspiring with one or more persons to commit the underlying offenses contained within those charges as well. This matter has already been decided by the Idaho Appellate Court in 2020, so it's a recent decision. The defense cited that and indicated that the court in Yang was wrong. However, the state disagrees with that. It was the exact same modification that was made in the Yang case. In Yang, the defendant argued there was a fatal variance between the elements instruction for conspiracy to traffic in marijuana and the second amended information charging him with that offense. And the citation to Yang is 167 Idaho 944. The court determined that a variance between a charging instrument and a jury instruction necessitates reversal only when it deprives the defendant of the right to fair notice or leaves him or her open to the risk of double jeopardy. As indicated, the second amended complaint in Yang contained there were three co-defendants laid out or co-conspirators, commas between each one, and before the last one, the word and. What the instruction was modified to was, again, the three co-conspirators, commas between each, and the inclusion of the and/or. That's the exact modification that was made in this case. Yang produced the exact same argument as what the defense is producing here. The district court originally rejected the argument, concluding the jury instruction could list the co-conspirators' identities disjunctively when the charging document listed them conjunctively without creating a fatal variance. The Idaho Court of Appeals also found use of and/or in instruction 18 did not create a fatal variance. Idaho Code Section 18-1701 requires that a defendant have an agreement to commit a crime with only one other person to form a conspiracy, not the number of individuals pled in the charging document. They cited to State v. Goggins, or said see State v. Goggins. That's 157 Idaho 1. They went on to say, additionally, the identity of a co-conspirator is not a necessary element of the crime of conspiracy. And again, going back to State v. Goggin, as well as United States v. Ray, which is 899 F3D 852. The court went on to look to multiple other jurisdictions that have looked at a very similar issue, and it is consistent that the courts have found whether pled conjunctively or disjunctively for purposes of a conspiracy is not a fatal variance. It's not a fatal error because it is not part of the conspiracy charge to prove the exact number of co-conspirators, nor is it an element to prove the identities. So I think the argument made by the defense is not quite on par with what the Yang court was actually looking at and finding. It's not just whether or not the defendant was on notice and whether or not defense counsel knows the definition of conspiracy. It's that those particular things are not even a required element to be proven within a conspiracy charge. And the fact that the defense was on notice that it was a conspiracy and the plain definition of a conspiracy being two or more persons. So the state would argue that that is not a ground to grant a new trial. The next one that we look to is whether or not the jury was misdirected in a matter of law or if there was an error in decision of any question of law during the trial. And specifically, the defense has focused on an amendment that was made to the indictment, amending the subsection regarding the charges involving grand theft. So there were two charges that were conspiracy to commit murder and grand theft, and then there was the separate grand theft charge. In those charges, they were counts 1, 3, and 7 of the indictment. The modification made, it was a clerical error, and the reason I say it's a clerical error and it's pretty clear is when you look at charge number 7 or count number 7 within the indictment, the language charged there comports with grand theft by deceit or by deception. The indictment specifically included the language, quote, by deceit and with intent to deprive, end quote. That's reflective of the language contained within Idaho Code 18-24032A. Originally, it had indicated 4A within that grand theft. If anything, that would have actually made the burden of proof higher on the state, because under subsection 4A, a person, there does not have to be any intent to, there doesn't have to be any deceit. There's no requirement that the state prove that it was done by deception. Under 18-24034A, a person commits theft when he knowingly receives, retains, conceals, obtains control over, possesses, or disposes of stolen property, knowing the property to have been stolen, or under such circumstances as would reasonably induce him to believe the property was stolen, and intends to deprive the owner permanently of the use or benefit of the property. 24032A provides that theft includes a wrongful taking, obtaining, or withholding of another's property with the intent prescribed in subsection 1 of this section, committed in any of the following ways. And then A is by deception, obtains or exerts control over property of the owner. The amendment in this case was simply to correct the subsection within the same statute, charging the same offense of grand theft.
Now, just a little stop here. I found this argument very compelling, that the mistaken section that was cited holds them to a higher standard than the one that it should have been originally. So, you know, if you're being held to a higher standard and you prove that, then you've proven the lesser one. So that really renders the assertion by the defense kind of silly. So here, let's listen to some more.
The defendant incorrectly indicates the modification changed the intent from an intent to deprive to an intent to deceive. Under both subsections, the intent is always to deprive. Under subsection 2A, there's simply the heightened burden that it be done through deception. The theft is committed through the use of deception. Further, the Idaho Supreme Court has looked at the modifications of indictments in State v. Bolus, 93 Idaho 749. In that particular case, a modification was made changing Idaho Code 18-1402 to 18-1401. The court found the indictment in the case clearly, the indictment in this case sets out clearly and in language easily understood the facts sufficient to establish the jurisdiction of the district court and the act or omission constituting the offense of which Bolus was convicted. The change in code sections from Idaho Code 18-1402, which describes the difference between burglary in the first degree and burglary in the second degree, to 18-1401, which defines the crime of burglary in general, did not have the effect of changing the offense with which appellant was charged. They went on to find no substantial rights of the appellant had been affected by the amendment because the unamended indictment was initially substantially sufficient to meet the requirements. Similarly, in State v. Dunn, that's 60 Idaho 568, the Idaho Supreme Court found the amendment did not charge a new or different offense, and it made no substantial difference as to the charge of obtaining money by false pretenses, whether the indictment stated appellant received the fictitious contract or executed it, because the balance of the indictment both before and after the amended impliedly charged appellant with having fabricated the contract. So similarly, in this case, the amendment still charges the defendant with grand theft, there's been no change in the underlying charge or offense. And additionally, State v. Severson is another case, and it was decided by the Idaho Supreme Court and is 147 Idaho 694. In that case, they also indicate an indictment may be amended at any time before the prosecution rests without being returned to the grand jury, so long as doing so does not prejudice the defendant's substantial rights or charge the defendant with a new offense. An amendment that merely alleges additional means by which the defendant may have committed the crime is permissible if it does not prejudice the defendant. Factors to determine whether the defendant was prejudiced include whether the amendment alleging the additional facts took the defendant by surprise, impaired the defendant's ability to adequately prepare his defense, necessitated extensive further preparation by the defendant, or subjected him to double jeopardy. They went on to find the defendant was not charged with a new offense since the amendment merely alleged an alternative way Severson might have committed the crime. It did not prejudice any of his substantial rights. In this case, similarly, the defendant was always on notice as to what the state was charging. As indicated, the language that would be contained within subsection 2A was always contained in the indictment. It simply referenced 4A instead of 2A. The defendant was always on notice that she was being charged with grand theft, which always includes an intent to deprive another of rightful ownership to property. So again, on that ground, the state would argue that the defense fails to meet any burden or that there would be any grounds for a new trial given that. The amendment was merely an alternative way and an alternative subsection within the crime of grand theft, not a new charge. And further, 2 of those were contained within a charge that was actually conspiracy to commit the grand theft. And finally, regarding the last argument, I think it appeared to be a combination of several of these, and specifically looking at whether or not the jury considered evidence not introduced. And also, I think the defense was referencing the verdict may be contrary to law or evidence within this. First and foremost, post-trial evidence as to juror post-conviction statements is inadmissible and prohibited under Idaho Rule of Evidence 606. Idaho Rule of Evidence 606B1 provides prohibited testimony or other evidence. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberations. The effect of anything on that juror's or another juror's vote or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statement on these matters. There are some exceptions to the exclusion of juror testimony outlined under Idaho Rule of Evidence 606B2. However, none of those would support the efforts being made by defense today. So the state's position, first and foremost, is any statements purported to be made by juror number 8 should not be considered by this court. The state would argue, however, if the court were to consider those statements purported by the defendant to support her attack on the court's instructions and evidentiary rulings, the defendant's motion would still fall on its face. As provided by the defendant in her motion for a new trial, juror 8 stated, quote, "We didn't consider this during our deliberations because it was clear to us. The instructions were clear. Arizona evidence and testimony is only for demonstrative purposes." And I understand now defense is trying to argue that they conflated that with demonstrative evidence. However, I think that's simply trying to determine what exactly the juror meant by that. A follow-up interview was conducted with that same juror where he responded, quote, "I personally did not," he was asked regarding whether he found the jury instructions to be confusing. He responded, quote, "I personally did not. I thought the judge gave us instructions throughout the trial, throughout the process, multiple times, and those instructions never changed in my opinion. Even up to the very last date, up to the moment before we were released to go deliberate, the instructions were clear." There is no evidence to support that there was any confusion regarding the 404B evidence and the demonstrative evidence. Juror 8 is unequivocal in stating the jury instructions were clear, and the 404B evidence was introduced, and that 404B evidence which was introduced was not considered for any purpose other than compliance with the instructions provided by the court. There was nothing to indicate that the juror did not follow the instructions provided by the court. And specifically, this court provided very clear instructions regarding 404B, which was provided under jury instruction 14. The court also advised the jurors every time there was 404B evidence being introduced that there would be a limiting instruction. The court then went on in jury instruction number 15 to specifically identify which exhibits were for demonstrative purposes, and those exhibits were not the 404B. So the juror saying repeatedly, the instructions were clear, the instructions were clear, those are two of the instructions that the juror is referencing by indicating that. As far as the review of any or consideration of any evidence that was not presented to the jurors, the defense purported that a statement made by that juror referencing some body cam footage of Charles that was not introduced at trial must have been considered by the juror. Again, however, in that follow-up interview, the juror specified he did not observe anything of that nature until after he had been released from jury duty and he did not view that until the Sunday after the verdict was delivered on Friday.
Yes, and this was exactly my interpretation when I watched the original interview with Nate Eaton. I never got the sense that that he had violated the duty as a juror not to go off and investigate on his own. And oops, I didn't know I turned on the comment here. Okay, let's get rid of that. Okay, back to the arguments. We still have a really good point that she comes up with here. So let's listen some more.
In addition, outside of Idaho Rule of Evidence 606, the Idaho Supreme Court in State v. Wrigley, that was 7 Idaho 292, has determined that the Supreme Court had previously determined, and Wrigley reiterated, the impeachment of the verdict by affidavits made after verdict rendered has never been recognized by this court. And that appears to be supportive of Idaho Rule of Evidence 606. The same analysis and reasoning apply. For all of these reasons, the state also, it's our position that the defendant has not met any burden or has failed to demonstrate that there are grounds for a new trial based on that allegation, which appears to encompass 2, 5, and 6 to some extent. So for the grounds listed by the defendant in the motion, the state would ask, based on those grounds, this court deny the motion. The state would also indicate and provided within the brief reference to the other 4 grounds that could be reason to grant a new trial. The state also believes there is no evidence to support that those would be grounds for a new trial. The state makes that reference since this court could independently determine that there would be a new ground for trial outside of those argued by the defendant. The state does not believe any of those 7 grounds are applicable in this case, and for all of those reasons would ask that this court simply deny the defendant's motion.
All right. Thank you, Ms. Blake, for your argument. Mr. Archibald, before we conclude, do you have any rebuttal argument?
Just briefly on the language of the indictment, to rebut what the state has argued, the court read the indictment to my client when this case started. The indictment language is that a conspiracy is 5 people. And so my client was put on notice that a conspiracy is 5 people. My client was not read the jury instructions when she was arraigned. The jury, when they were summoned to appear in Boise, when the case started, they were put on notice.
Just a thing, nobody has ever read the final jury instructions when they're indicted, because those have to be argued and crafted. So that argument is completely spurious. So good, you know, good effort, but you know, must try harder.
Because the court read the indictment to them. They were put on notice that a conspiracy is 5 people. And not until 7 weeks later was the jury and my client told that, just kidding, a conspiracy is really 2 or more. So that's why this Yang case out of the Court of Appeals is wrongly decided, and it focuses on the wrong issue. The issue here is, what was my client advised of? And the Yang court says, well, defense counsel knows what a conspiracy is, so that's why it's not a big deal. But are defense lawyers supposed to tell our clients, hey, just ignore what the judge just read to you. Just ignore what the grand jury indicted you on. The judge just read to you that you're accused of being in a conspiracy of 5 people. Ignore that. Ignore what the grand jury said. Ignore what the judge said. Listen to me, your defense lawyer. A conspiracy is really 2 or more people. And that's why this Yang decision is totally wrong, because my client was put on notice by the judge, by the grand jury, as to what she was accused of. And that's why this justifies a new trial.
All right, thank you, Mr. Archibald. Counsel, I'm going to briefly go back through your arguments as well as a few of the citations. I'll be prepared to make a ruling on the motion this morning, but we'll take a break first so I can get my thoughts together. So we will plan on reconvening here in about 20 minutes. All right, we are back on the record on KCR 22-21-1624, State of Idaho versus Lori Noreen Vallow. The court took a recess after considering the arguments that were submitted by both the defendant in its motion for a new trial and also considering the response from the state and the state's objection that was filed as well. So the court is prepared to make a ruling on the motion for a new trial at this time. And I will walk through those issues that were raised in the motion in turn. So the first motion rationale is under subsection 1, a argument that the court misdirected the jury as a matter of law as it relates to the jury instruction on conspiracy. And the argument being that the language in the indictment and amended indictment talked about a conspiracy said between the defendant, Chad Daybell, Alex Cox, and others, which the defense argues would need a minimum of 5 people to be complicit in the conspiracy. The state, upon request, and the court considered it and heard argument on it at the time, I'll note, on our jury instruction conference, requested a jury instruction that had and/or language which could then allow the jurors to consider a conspiracy of 2 or more people. So the argument is that would be grounds for a new trial. I would note at the outset, the grounds for a new trial, as mentioned by both sides, must be found under a statute or rule. Rule 34 of the Idaho Criminal Rules allows for a motion for new trial, and the statute relied on here is Idaho Code 19-2406, which sets out 7 different subsections of what may be used to justify a new trial. So going back to the conspiracy question then, and whether or not that was a misinstruction as to the matter, as a matter of law, the court has reviewed the citations and authority. There is the State versus Yang case, which I do agree is substantially similar in its analysis of this issue of and/or. And one of the quotations from the State versus Yang case, and that's the 167 Idaho 944, is whether or not alleged co-conspirators were listed conjunctively or disjunctively, and the jury instructions was immaterial. There was other language in there indicating whether or not that, number one, constitutes a variance, and the standard then, after you find if there is a variance, does the variance become what the law calls fatal? And you would have to make a finding that it would somehow violate due process. So that's the standard the court's looked at. There's also a very recent case called State versus Anderson, which came out on June 7th of 2023. So currently just has a Westlaw citation of 2023 Westlaw 3855252. And the Anderson case talks about this issue as well. And one of the citations out of that says, quote, "The facts set out in the charging document therefore put Anderson on notice that both theories of assault were at issue. While there was a variance between the charging document and the jury instruction, we hold that the variance was not fatal." A few things on this as it relates to the conspiracy charge. If there was a variance between that and instead of and or, as differing between the jury instruction and the indictment, the court would not find in this case that there's been a showing that it would violate due process. In order to violate due process and therefore become a fatal variance, first you have to determine there was the variance, and second, is a reversal necessary because it deprives the defendant of fair notice or leaves them open to the risk of double jeopardy. A variance between a charging document and instructions is fatal if it hindered the defense in the preparation or presentation of their defense. A couple of things that were noted by the state is Idaho Code 18-1701 is the defined crime under which the charge took place of conspiracy, and that plainly states that a conspiracy involves two or more persons. So there wasn't an instruction that went contrary to what the statute says. Also, and looking back at that new Anderson case as well, the question is whether or not in the conspiracy the defendant had notice of the facts that were underlying the conspiracy. And the court would note, importantly here, the overt acts in the indictment did not change. There wasn't an amendment to the indictment that allowed for any additional overt acts that were not originally included in there. And those overt acts in general talked about the named co-conspirators, meaning the defendant, Chad Daybell and Alex Cox, in the overt act language. When the court considers overall whether or not that could have resulted in any hindrance of the defense in preparation or presentation of the defense, I don't find that there's been a showing that if there was a variance here, that it was a fatal variance as defined in that case law, and in particular also, again, the State versus Yang case that's been cited by the state. And so upon consideration of that, the court does determine that the first grounds for the new trial of an allegation that the jury was impermissibly instructed on conspiracy, I'll deny that motion on that ground. The second issue raised is whether or not the court misdirected the jury as a matter of law as it related to the amended indictment. On this argument, the procedural history was that the state moved at the close of its case to change and amend the indictment in this case of what it calls a clerical error. There was a description of charges in the indictment relating to the grand theft charges. The indictment spelled out that it was grand theft by deception. In other words, it had the language in there, grand theft by deception. However, the 2403 subsection did not comport with the language. So it was a grand theft citation, but it was not the specific grand theft by deception citation. When the state moved to amend the indictment at trial, the court heard argument on this specific issue and made a ruling permitting, under Idaho Criminal Rule 7E, the amendment of the indictment. And I'll incorporate the findings I made at the time of trial when I allowed for the indictment to be amended in this decision, finding that it was a permissible amendment given the time and the nature of the amendment. Also, as it relates to the argument now that that was a misinstruction or an error for the court to allow that to be amended, the states argued that the amendment in fact increased their burden to use a more specific type of theft, which has additional elements on the theft by deception. And the court would agree with that argument, that it did not lessen any burden the state had. And where the language always had put the defendant on notice, the court finds that by simply changing the number and letter of the code site, which the jury of course would not have access to, that it did not in any way rise to the level of one of the subsections of 192406 to allow for a new trial on that argument as well. So on that second argument then made by the defense as to a new trial, the court will deny the motion for a new trial there. That brings us then to the third grounds for a new trial, which involves allegations that a juror interview has revealed that the jurors perhaps were not properly instructed, or that the jurors were somehow didn't deliberate correctly based on the court's instructions, and that's been a grounds for the court to an argument for a new trial. I've considered that, and first, as it came out in the motion, I did have a concern that it was just a motion where, in argument, the defense says, well, there's been an interview of this juror, and here's what the juror said in the interview, and it's not submitted to the court through any declaration or affidavit. So I didn't really consider that to be evidence in the first place, the way it came to the court. The defense has argued, well, the state's agreed that that's what was said in this interview. I'll note that I don't go in and independently listen to or review the interviews unless I have a reason within the rules to do that, and I've not done that in this case. So first, I don't necessarily really have any statements from that juror before me. The rule of evidence 606 does go directly to this issue, and that rule is called juror's competency as a witness. The state notes that subsection 1 of Rule of Evidence 606B1 prohibits the court from considering these statements. It says the court may not receive a juror's affidavit or evidence of a juror's statement on these matters. And that matters being the jury's deliberations, the effect of anything on that juror's vote, or the juror's mental process concerning the verdict or indictment. So as it relates to what's been alleged here, I mean, at the outset, I just think it's pretty clear that there's a strong policy that jurors' deliberations are sacrosanct and we don't interfere with the manner in which they deliberate, nor do we go in and require them to start answering questions in any proceeding about how and why they reached a verdict. I would note, of course, there are the exceptions then under Part 2 that occasionally, under narrow circumstances, that can be permitted. In this case, if I look at those exceptions, number one, it's under 2A, was there any extraneous, so going back, if there was to the court submitted some sort of a declaration or affidavit from a juror stating, hey, here's what happened, and it falls within one of these exceptions, then the court could consider whether or not the verdict should be set aside and a new trial granted. The first exception is whether or not there's any extraneous prejudicial information improperly brought to the jury's attention. And the court would note during the course of the trial, the jurors each day signed a daily affirmation in a declaration and submitted those to the court that they had not received any improper prejudicial information because they were instructed they were prohibited from looking anything up in the case, and they affirmed to the court each day, all 12 of the jurors on every single day, that they hadn't done that. So that's the evidence the court has before it in terms of what is in the record. Part B is whether any outside influence was improperly brought to bear on any juror. There was never any contact made to the court by any juror about any outside influence. And again, that daily affidavit also, I think, probably would cover that issue. So I don't consider there's any record that that occurred. There's no indication that the jury determined any issue by resort to chance. So I don't have any specific information that they drew straws or flipped a coin or something else, decided by lot any of their convictions in this case. And then any allegation that there was a mistake made in entering the verdict on the verdict form. And I'd note there, with the last exception also, the jury came back with the verdict form. The jury was polled after the verdict. The jury independently, each one of the 12 confirmed their verdict. And so the record before the court doesn't show any of those exceptions would apply. If I do look at the allegation that a juror conflated demonstrative versus 404B evidence, again, looking at whether or not that falls within an exception under Rule 606, number one, I don't have before me any declaration of the juror or other evidence I would consider that the juror, in fact, ran afoul of one of those exceptions, even if the juror had misidentified or misunderstood even the 404B versus demonstrative exhibits. The court would also note that it had a specific jury instruction, which was jury instruction number 15, about demonstrative exhibits that identified exactly which exhibits were the demonstrative exhibits, and also that the jurors did not have that information with them when they deliberated because it was made available upon request by note. We didn't receive a request during deliberations. And the 404B instruction was given by the court during testimony and during trial. And so while a juror may have said something that conflated those two terms, the question is whether or not the court can even go there and consider what the juror may have said or understood under Rule 606 B1, and the court finds that the exceptions under 2 don't apply here with the record before the court, and I also find that the court can't consider those statements as they fall outside of the exceptions. So to the extent that any representation of what this juror number 8 may or may not have said, even if I considered that potential misunderstanding, I wouldn't find that it would rise to the grounds of allowing for a new trial under any of the exceptions under 19-2406. So the specific exceptions under 2406, under 2, 5, and 6, which were argued, the court would determine those have not given grounds in the court's discretion for the court to set aside a verdict in this case and allow for a new trial. The other uncited provisions of 1924-06, 1, 3, 4, and 7, I also find there's no evidence supporting the granting of a new trial on those grounds either. And so for those reasons, and finally I'll cite, there was a case cite of Hall versus State 151 Idaho 42 on this issue of the jurors, and that talks about that juror statements are the only way to ascertain what took place in the deliberative process, and it's reiterating that the rule is to make those lines of inquiry pertaining to those issues inherently fruitless, so essentially not allowing parties to go in and try to pry into the minds of what the jurors did when they deliberated. For all those reasons, then, the court's considered thoroughly the motion for a new trial as it relates to those statutory grounds, and I don't find any sufficient evidence has been submitted to the court allowing for a new trial to be granted. For that reason, the court is going to deny the motion, and the court will proceed on July 31st with sentencing in the case. That'll be the ruling today then. Any questions on the court's ruling, Mr. Archibald?
No questions. Thank you.
All right, thank you. Any questions from the state, Ms. Blake? All right, thanks, counsel, for your briefing and arguments today. That will conclude the hearing. We'll be in recess.
All right.
Okay, and that was the hearing. Now, when I was listening to it right after the decision came down during the middle of the yes, Lori will keep appealing. Hi, Samantha. This was just the judge asking the judge to grant a new trial. It's not technically an appeal at this stage, but from the language in the Yang decision and the other material that was cited by the prosecution, the judge had no other option than to rule the way he did because of there were two Idaho Supreme Court decisions that gave very clear direction on what should be done in this case. Now, if we have another case which comes from the I'm not sure, I assume they're in the 10th district like Utah is, but I could be mistaken on that point. If there is a decision which comes from the that or the U.S. Supreme Court, then of course they would have to go by that. Or if there is a Idaho Supreme Court case that rules differently, but one of these two cases cited was just earlier this year, so it's quite recent and unlikely to get overturned so quickly because that's usually it takes time for the court to come to a conclusion that things need to be different. So there's not really any grounds for this to be overturned on the appeal, in my opinion, on the matters that were here, because the cases cited were so strong in this instance. The prosecution referred to Yang, and the judge was the one who came up with the more recent decision, and those were both affirming the judge's ruling on this. So yes, we will have appeals going on for years, if not decades, on this. That's just how it always goes. Lori's delusion, I'm not sure I think it must be pleasant to be in her own little mind, because she can have everything just the way she wants it to there. And now that she has been competent and gone through trial, she doesn't have to be competent from here on out. She can be as crazy as a loon in prison. As far as we're concerned, it's not doesn't really matter at this point, because we got her through the trial. So yes, she does have a bizarre mind. And I don't know. I'd kind of like see an examination of what was Lori like in her younger days, before Chad ever came along. I kind of suspect she was always a bit of a narcissist and so forth. We will have sentencing on July 31st. I'm not sure just when that hearing is. That's also the date of the next Jim Brenner hearing. And so Nate Eaton asked me to keep him informed of what happens on Dillon Rounds that day. And he's going to be there in Idaho covering Lori's sentencing. So, and I should see about whether I can get media credentials, and then maybe I can record it. And that would be super. So I need to get doing that. Let's see, was there something else which came up? I was temporarily demonetized because I was supposed to do some stuff for tax purposes and so forth, and I was putting that off, and so I finally got that taken care of, and trying to get a PayPal set up for those if they ever want to do a in lieu of a super chat, since YouTube takes a third of that. But we're moving on, and I've been suffering from acute trial withdrawal. The Corey Richens hearing on Monday was far more than I ever expected from a hearing, but it's probably going to be a year or more before that gets to trial. So if you have any cases which are going to be broadcast and want me to cover, let me know, because I'm trying to find another interesting one. For some reason, it seems like all the cases that keep coming up are rap stars, either as the victim or as the killer. And for some reason, those don't really interest me. But I'm hoping that we'll have another good trial coming up here soon. So, oh yes, Corey Richens saying she's not gonna make it. She's trying to go for pity and hoping that the cameras overheard that, so that she can try to get pity from people. I should make business cards and fridge magnets. Yeah, I've been maybe in cross stitch since I like to do needlework. Oh, I should find this segment if it's on YouTube. I don't know if it is. There was a comedy series sketches, kind of like Monty Python, and it was called The Canadian Air Farce. And there was an excellent sketch on there where you had the Martha Stewart doing the national news, and she would be doing the news mixed with craft spots, and the logo for the news network was done in needlework in the background. So that was That was pretty hilarious. Yeah, is there any progress on the Oregon serial killer? Have they said any more evidence connecting these victims in Oregon? Because that does sound pretty compelling that you got 6 women who end up dead with similar demographics and so forth. Got so much craft paper from the thrift store yesterday. Ooh, excellent. I love to visit thrift stores, but I need to do it a little less right now because I've got too much stuff and I need to get through some of putting my stuff away, and I just acquired a new doll the other day. I need to get my doll collection put out and properly displayed again. So, yeah. Let's see. So, and yesterday we had the 2-year anniversary of the disappearance of Summer Wells, and recently Don B did a video suggesting that Summer might have been rehomed with someone, probably with the idea of keeping her out of the hands of CPS and from being examined so that Dawn Wells wouldn't be in risk of going to jail for life. So, yeah, the junk and old paperwork. I got telephone answer pads, it said. Yeah, I've got some of those what do you call it? The little thin envelopes that you used to have for air mail. I picked up a bunch of those. I should mail you some. Don had a personality transplant. Well, he needed one. Somehow I would think it was only temporary. Somebody yesterday, I can't remember what the channel was because it wasn't one that I had encountered before, did a handwriting analysis on supposed to be Dawn and Candace, and I came in late. It was a short one. I don't know, maybe 15 minutes or so in length. And I need to go back and watch that because I was thinking at first the handwriting looked too nice to be Dawn's, but from what the handwriting analyst said, I'm going, well, some of that does sound awful like Dawn, but I'm not convinced that the handwriting isn't done by Tim Mullins. And Dawn's got a jail, Jesus. Yeah. I haven't heard Billy Ray on YouTube. I haven't heard of them. Anyway, the idea that Summer was rehomed had come up in a live stream over a year ago, and somebody was suggesting that Clyda Trent, who Dawn's mother turned the house over to her when she died, and then she conveyed it to Dawn. Somebody said they thought that Summer was with Clyda Trent, and Clyda Trent lives down in Pleasant Grove, and so I'm thinking when I get ahead a bit on having some more gas money of making a trip down to the 2 addresses, the last address and the present address for Clyda Trent. It's about 40-minute drive to see if there's any sign that Clyda has a minor girl living with her. So, in fact, I might have suggested that the other day, but I was off with Gordon trying to get court paperwork in for the eviction hearing yesterday, and And that was a big fiasco because it was right at closing time. And so to save time, said, well, email the documents to Gordon. He paid $5 for them to do that. And then he would forward the documents on to the defendant, and then we'd print them out at the library so that we had copies of them, and she had access to them. And the email didn't go through, and because it was late, we weren't able to go back to the court clerk and say, hey, we've got a problem. And so the judge yesterday said, okay, everybody submit their evidence again, from scratch. And so it's been postponed till next Wednesday. And so I'll be going to Corey Richens' scheduling hearing in Park City at noon, and then this eviction hearing for the finances and her spurious countersuit later in the afternoon. So 3 of the girls were working girls on our 40-mile bike path. That long. Yeah, working girls are part of the population which are called the less dead, because they are very transient and people look down on them. And, because of the transient lifestyle, they don't really pay attention that much if they disappear, because they go from area to area. And, they have a high risk lifestyle, and people aren't really concerned if they disappear. So it's sad, and they have as much right to justice and to live out their life to the natural end, even if they are living a lifestyle which is in contrary to the laws and in their profession. But that profession is not a capital offense, so nobody has a right to go killing them off. So Billy Ray local coverage Portland unhoused population. I found him recently. Oh, okay. So he's covering the Oregon case. Okay. Well, I'll have to keep track, because it's a fascinating case that's developing there. Kind of I'm getting a bit of the Green River Killer vibe from that. Maybe the killer is emulating him. Yeah, unfortunately, drugs, sex trade, and being homeless, or what is the term? Transient, in the terms of they may have a place, but they go from place to place to place very frequent. So they are always in a state of transition between places. So yes. So Gizzy Sue, keep me posted on that, and I'll try to look up this Belly Ray to learn more about that, because that's a fascinating situation. And I'm seeing some videos about what's his name, the Delphi killer accused, and that he's supposed to have confessed, and I haven't had a chance to watch that. So I think that I'll probably do that this afternoon. You're feeding the cats. Well, I've got Aowen curled up right here next to me, and I'm thinking of splurging on more expensive cat food and see if that keeps her from getting sick. I always attributed to her eating too fast, but somebody said that better cat food might be the help. So anyway, that's what we've got for Lori Vallow and her request for a new hearing, or a new trial. That's pretty much doomed to fail, because you're asking the judge who already made the decision to say he was wrong. And judges don't like to say that they're wrong, especially without some real compelling reason, and there just wasn't any. JLR did a Delphi Live this morning, I see. I think there was one by, there might have been one by Grizzly True Crime, which caught my eye that I was thinking of taking a look at. But I'm very interested in that, and I sure hope that the Delphi trial is broadcast, because that's going to be a fascinating case. And I think I was watching something yesterday where they were talking about it, and there was one person in the chat who was going, I don't think he did it, or maybe it was a commenter. And no, I think he did it, and I think that what's his name, the father and son duo, can't remember his name at the moment. I think that, as I understand it, that Richard Allen was supposed to procure these girls so that he could take them over to the old guy whose property it was, and he's supposed to be meeting up with some offenders, so these girls could be abused, but something happened, and he killed them instead. But not necessarily. You would think that's a no-brainer. If he confessed, there's no trial, but you have issues about what happened, and it depends on the confession and so forth, and how the penalty goes down. So yeah, right now I'm all the names are eluding me. Keegan Klein, is that it? Yes. Yes, great minds think alike. We both thought it at the same time. Yes. Well, there's so many names on so many cases that it's hard to keep them all straight sometimes. And so, yeah. So yeah, the Delphi, that's one if that's televised, I definitely want to cover that case. And of course, Chad Daybell and Jim Brenner and Corey Richens, who looks like a real piece of work. I couldn't believe the financial stuff that we were hearing at the detention hearing. that was pretty wild. I want to know Alan's thinking. It's going to be fascinating. And I don't know. There was one channel. I can't remember the exact name of it. Something from my sofa, live from my sofa, something like that. And he is a hoot. And he read the Loin Fire, and he read Chad Daybell's memoir as a grave digger. And I don't know, I'm kind of tempted to play those, and we can have a hoot commenting on those, because those were both rather interesting, and insight into the Gravedigger book was interesting as to his mindset, how he thinks. So I might check into that and set up that. So aliens would never come here. There's no intelligent life. Well, I think there's pockets where there's intelligent life, but unfortunately there's a lot of areas that they would have to look hard to find it. So Oh, yeah, that's probably it. Let me take a look here. Let's see. Yeah, reporting from my sofa. I came across him in the towards the tail end of Lori's trial, and he's got such a great sense of humor, and his commentary on Loinfire and Chad's memoir are it's so funny. So no, he's not British. I'm not sure where he's from. He could possibly be Canadian. I always assumed he was American, though. So I guess that's it. Time to sign off, I guess. And next week, I'll do an update on Corey Richens and the scheduling hearing, and seeing if we got a trial date set forth. But whether or not that trial date actually stands is another matter, because so often you've got so many scheduling changes. I mean, some channel, I might have been Court TV, was thinking that, it sounded like they'd try to get the trial within a year, but it doesn't always advantage the defense to have a trial that quick. And if it's not a death penalty case, which sounds like it probably won't be, because those are very rare in this day and age, that it's most likely not going to be a death penalty. And have to do some interviews with, or some things. Megan Boswell, I'm not sure if that one is going to trial or not. Let's see. Just a sec here. Okay, this says trial pushed to 2023. Let's see when. Okay, as of this, which was in a year ago yesterday, it was going to be February 2023, and I'm pretty sure that was postponed. So let me take a little bit look further, because that would have been contemporary with when the Murdaugh trial was going on. Let's see. I'm not seeing, but I'm pretty sure that one hasn't taken place. Let's take a look on YouTube here. Megan trial moved to February 2025, so we are a good ways out from Megan Boswell's trial. That one is about 20 months out. So anyway, if you hear of any compelling cases which are coming up for trial, which are we'll take a look at covering it. Just let me know, and I guess we'll sign off. It's been pleasant to visit with you. Yeah, Megan is the mother of the 17-month. Oh, was she dumped in the trash? Yeah, 2025. I was shocked by that, because That's quite the ways out. Unless this is a typographical error, but I see that in more than one place. So from WBIR and WJHL both have it listed as February 2025. So you've got two independent news sources. I think that we can pretty much rely on those. Brianna Lopez. I'm not sure. Let me take a quick look. Oh, that was says 20 years later. Yes, I heard about that. I heard about that recently, but I haven't really studied up on that case. So, yeah, I'm sure. There was something, I think, last month that they were talking about it. I don't know if there was they were coming up for a prosecution at last, or they were revisiting it for some reason. But anyway, that was a disturbing case. So, okay, well, I think time to go off, and you have a good evening over there, Samantha, and I guess Gizzy, Sue, and I will have a good afternoon. So, we'll catch you later. Bye-bye.